Welcome to Middle Class Matters. Today, 19th June 2023, Business News in English from Dr. CMA M.V. ALAGESAN. We will see on Framework for Compromise Settlements and Technical Writes-Off. This is a circular from RBI / 2023-24/40 DOR.str.rec.20/21 April 21.04.048/2023-24 8th June 2023. This is applicable to commercial banks including small finance banks, local area banks and regional rural banks, primary urban cooperative banks, state cooperative banks, central cooperative banks, all India financial institutions, non-banking financial companies including housing finance companies. The Reserve Bank of India has issued various instructions to regulated entities REs regarding compromise settlements in respect of stressed accounts from time to time, including the Prudential Framework for Resolution of Stressed Assets dated June 7, 2019, within bracket Prudential Framework, which recognizes compromise settlements as a valid resolution plan with a view to provide further impetus to resolution of stressed assets in the system, as well as to rationalize and harmonize the instructions across all regulated entities as announced in the Statement on Developmental and Regulatory Policies released on June 8, 2023. It has been decided to issue a comprehensive regulatory framework governing compromise settlements and technical write-offs covering all the regulated entities as detailed in the annex. Point number 2. The provisions of this framework shall be applicable to all REs to which the circular is addressed and shall be without prejudice to the provisions of the prudential framework or any other guidelines applicable to the REs on resolution of stressed assets. Point number 3. These instructions on operationalizing the framework have been issued in exercise of the powers conferred by the sections 21 and 35A of the Banking Regulation Act 1949, read with section 56 of the Banking Regulation Act 1949. Chapter 3B of the Reserve Bank of India Act 1934 and sections 30A, 32 and 33 of the National Housing Bank Act 1987. They shall come into force with immediate effect, and REs shall take necessary steps to ensure compliance with these instructions. Annexure. Framework for Compromise Settlements and Technical Write-Offs. Board Approved Policy. Point number 1. Regulated entities REs shall put in place board approved policies for undertaking compromise settlements with the borrowers as well as for technical write-offs. Compromise settlements for this purpose shall refer to any negotiated arrangement with the borrower to fully settle the claims of the RE against the borrower in cash. It may entail some sacrifice of the amount due from the borrower on the part of the REs with corresponding waiver of claims of the RE against the borrower to that extent. Technical write-off for this purpose shall refer to cases where the non-performing assets remain outstanding at borrower's loan account level but are written off within bracket fully or partially close the bracket by the RE only for accounting purposes without involving any waiver of claims against the borrower and without prejudice to the recovery of the same. Point number 2. The board approved policy shall comprehensively lay down the process to be followed for all compromise settlements and technical write-offs, with specific guidance on the necessary conditions precedent, such as minimum aging, deterioration in collateral value, etc. The policy shall also put in place a graded framework for examination of staff accountability in such cases with reasonable thresholds and timelines as may be decided by the board. Point number 3. In respect of compromise settlements, the policy shall, inter alia, contain provisions relating to permissible sacrifice for various categories of exposures while arriving at the settlement amount, after prudently reckoning the current realizable value of security or collateral where available. The methodology for arriving at the realizable value of the security shall also form part of the policy. The objective shall be to maximize the possible recovery from a distressed borrower at minimum expense in the best interest of the regulated entity RE. Point number 4. The compromise settlements and technical write-offs shall be without prejudice to any mutually agreed contractual provisions between the RE and the borrower relating to future contingent realizations or recovery by the RE, subject to such claims not being recognized in any manner on the balance sheet of REs at the time of settlement or subsequently till actual realization of such receivables. Any such claims recognized on the balance sheet of the RE shall render the arrangement to be treated as restructuring in terms of para 7 of this circular. Delegation of power. 5. The aforesaid policy shall also cover the delegation of powers for approval or sanction of compromise settlements and technical write-offs. Point number 6. In respect of compromise settlements, it shall be ensured that 1. Delegation of power for such approvals rest with an authority, individual or committee as the case may be, which is at least one level higher in hierarchy than the authority vested with power to sanction the credit or investment exposure, provided that any official was part of the sanctioning the loan as individual or part of a committee shall not be part of the approving the proposal for compromise settlement of the same loan account in any capacity. 2. Proposals for compromise settlements in respect of debtors classified as fraud or willful defaulter as permitted in terms of class 13 of this annex shall require approval of the board in all cases. Prudential treatment. Point number 7. Compromise settlements where the time for repayment of the agreed settlement amount exceeds 3 months shall be treated as restructuring and defined in terms of the Prudential Framework on Resolution of Stressed Assets dated June 7, 2019. Point number 8. In case of partial technical write-offs, the prudential requirements in respect of residual exposure, including provisioning and asset classification, shall be with reference to the original exposure, provided that the amount of provision, including the amount representing capital, including representing partial technical write-offs, shall meet the extant provisioning requirements as computed on the gross value of the asset. Reporting mechanism. Point number 9. There shall be a reporting mechanism to the next higher authority, at least on a quarterly basis, with respect to compromise settlements and technical write-offs approved by a particular authority. Compromise settlements and technical write-offs approved by the MD and CEO or board level committee would be reported to the board. Oversight by the board. Point number 10. The board shall mandate a suitable reporting format so as to ensure adequate coverage of the following aspects at the minimum. 1. Trend in number of accounts and amounts subjected to compromise settlement and or technical write-off, quarter on quarter and year on year. Point number 2. Out of one above, separate breakup of accounts classified as fraud, red flag, willful default and quick mortality accounts. Point number 3. Amount wise, sanctioning authority wise and business segment or asset class wise grouping of such accounts. 4. Extent of recovery in technically written off accounts. Cooling period. Point number 11. In respect of borrowers subject to compromise settlements, there shall be a cooling period as determined by the respective board approved policies before the REs can assume fresh exposures to such borrowers, provided that 1. The cooling period in respect of exposures other than farm credit exposures shall be subject to a floor of 12 months. REs are free to stipulate higher cooling periods in terms of their board approved policies. Point number 2. The cooling period for farm credit exposures shall be determined by the REs as per the respective board approved policies. Farm credit for the above purposes shall refer to credit extended to agricultural activities as listed in Annexure 2 to the Master Circular, Prudential Norms on Income Recognition, Asset Classification and Provisioning pertaining to advances as amended from time to time. Point number 12. The cooling period to be adapted in respect of exposures subjected to technical write-offs shall be as per the board approved policies of the REs. Treatment of accounts categorized as fraud and willful defaulter. Point number 13. REs may undertake compromise settlements or technical write-offs in respect of accounts categorized as willful defaulters or fraud without prejudice to the criminal proceedings underway against such debtors. Other legal provisions. Point number 14. The compromise settlements with the borrowers under the above framework shall be without prejudice to the provisions of any other statute in force. Point number 15. Further, whenever REs had commenced recovery proceedings under a judicial forum and the same is pending before such judicial forum, any settlement arrived at with the borrower shall be subject to obtaining a consent decree from the concerned judicial authorities. List of circulars that stand repealed with immediate effect. DPOD number BPBC 81/21.01.040/95 excluding paragraph 2 dated 28/7/1995 on compromise or negotiated settlements of non-performing assets NPAs. Second circular DPOD.BB.BC.55/21.04.117/2007-08 dated 31/11/2007. Guidelines on settlement of non-performing assets obtaining consent decree from court. Third, DPOD-BP.BC.NO.11.2/21.04.048/2009-10 dated 21/6/2010. Compromise negotiated one-time settlement of non-performing assets. Thanks for watching. Please like the video, subscribe to the channel. Thanks for watching.